Well, good afternoon. Thank you. I was just about to start looking at a case called Cow Watch when we broke for the short adjournment. I wonder if I could do that now. That's your tab 19. This is a 2014 case before Mr. Justice Henderson, as there was. This case is perhaps better known, and you may have it in your mind, as being a case concerned with implied terms in relational contracts, good faith implied terms. It followed up from Mr. Justice Leggard's earlier foray into that.
Yeah.
It's got one or two things to say about the subject that we're on, so it's a long enough judgment, and I don't need to go through all of it.
No.
If I could invite you just to go with me, please, to the foot of page 415, that's bundle 415, paragraph 126 of the judgment. And we would respectfully submit what we pick up here. And I'm just going to invite you just to read into those few lines so you see where we're going, but then I'm going to take your attention to page 4116, please, 416. So if we could go there, what we see is a pretty standard recitation of the principles to which I have already introduced you. So Norton Maxim Nordenfeld to start with, and a quote you've already seen. Paragraph 127, Dynarod, you've seen. Mr. Justice Whitworth in Prontoprint, you've seen the statement from Mr. Justice Whitworth, but not the case, but you've got the quote. Judge Roger Cook, Colquick, Mr. Justice Newberger in Dynarod. And then paragraph 128, Chips Away, which we've just looked at. So I don't think there's anything specific there, but I bring it to your Lordship's attention simply because it, as it were, encapsulates, we would say fairly conventionally, everything that we have endeavoured to walk the court through this morning. Then, if I may,
Could I
please
just ask you very quickly?
Yes.
One of the things that arose in this case, by reference to an earlier case, if you look at 134, where he notes that one of the things that was involved was a restriction on business that is similar. And he notes that that seems to have been upheld by Mr. Justice Whitford in Prontoprint, albeit without argument. But then he notes that in Convenience and Roberts, it was struck down. I wondered if you've got any submission to make about that.
I hadn't looked at Convenience for this purpose, and forgive me, perhaps I showed it, and I'll look at it overnight if your Lordship would want some help with it. But it would seem to me, on the face of it, that in the context of this particular case, if relevant, would be looking at ground 2 and just taking out the word similar, which could be easily blue penciled away were the court to think that was an issue. Right. So I think it's a ground 2 point rather than the ground 1 point. Because ground 2 looks, I may be wrong, one always runs that risk.
But you would accept that the width of the covenant in that sense is reasonable when ascertaining it, is a relevant consideration when considering reasonableness. Oh,
certainly, yes.
And on its face, it points against reasonableness.
If the position is that there is binding authority to the effect that something similar to or competitive with is inappropriate.
Well, the point is you've got competitive to, that's one thing, and then you've got similar to, which is another because it's broader. Plainly, it extends the protection beyond that which is competitive to that which is similar. And that, as I understand it, is the reason why it was struck down in Convenience and Roberts. That was held to be too wide. And I'm not asking you to concede the point in the present case. All I'm asking you to is whether you would accept that for that reason, it's more likely to be unreasonable than simply a covenant against something that is competitive.
I think the answer, perhaps this is not a way of trying to avoid your lordship's question, but can I think about it? Because if, for example, there would be gradations of competition, and you could have circumstances in which the business you're in would give rise to potential loss of goodwill from something that was similar to, because you might be talking about, for example, the method by which the service was being delivered. So I'm not, at the moment, without thinking about it, anxious to make a concession per se. I can see your lordship's looking at the word.
Illustrated by reference to the facts of the present case, because your clients are in the emergency plumbing business, broadly speaking. And a directly competitive business is one in the emergency plumbing field, whereas or similar to, one might have thought could well extend to any form of plumbing, even that which is planned years in advance.
Well, Lord, perhaps where I would see the similarity would work is in a broader company which included the possibility of emergency, rather than a broader based company that did not undertake emergencies, because the emergency part they wouldn't line up to be a directly competitive business per se, but the emergency part of the broader company would qualify under similar. So, Lord, that's why I just want to give that some thought. It's not something I have given particular thought to, because I'm, for my part, on the face of it, was content really, when we get to this, I was content to rest on policing provisions for some of what I'm going to call the back end of paragraph 305. In other words, we've been spending our time so far in this appeal on the first 4, 5, possibly 6 sub-paragraphs. There are others to look at as well. And then there's ground 2 to fall back on. So I have to say, perhaps mistakenly, but I had rather focused on points of key principle that I thought were between the parties rather than that particular point. So I still think there would be a way of...
It's a fair point to make that you can't view these points in isolation. I mean, as we see from what's said in 134, in the convenience case, it wasn't purely the fact that it was similar. It was the combination of the fact that it was similar together with the territorial scope. So one has to look at these points together.
That I entirely understand, but it still seems to me that there would be a way of construing this clause in order to ensure that it was reasonable. It depends on what similarity meant, and that's fact specific. So the question of its fact specificity would be an issue when in fact one was then looking at breach of the covenant if you were trying to get someone to be injuncted, for example, or suing for damages for breach of it. So I'm not sure at the moment I'd be ready to concede that the simple inclusion of the words similar or is more likely to make this unreasonable than not, for the reasons I've expressed.
Why don't you look at convenience and roles overnight?
Lord, I'm so sorry, I didn't hear.
Think about it, then make the submissions tomorrow.
May I do that? I prefer to have a think about it before I commit the appellants one way or the other.
Where are we going next, Mr. Jones?
So where I wanted to go next, please, was to a case called Guest Services. Guest Services we will find in our bundle, page 467 is the page I think that I've got marked. Well, I've given myself a false reference, will you forgive me?
Tab 25.
Yes, it's 646, I'm sorry, I'm having a 646, thank you. I misread. I've armed myself with both report page numbers and bundle page numbers, which is not helpful if one reads the wrong one, I'm so sorry. So I wanted to ask you to look at, please, with me, just page 646 and over to 647. So this is paragraph 41. This is again a Court of Appeal case. Lord Lady Justice Atwood There is no dispute that all covenants in restraint of trade are prima facie unenforceable at common law unless they're reasonable. The first issue in such circumstances determines the level of scrutiny which is appropriate. Mr Bartlett says the court is less vigilant where covenants of this kind are contained in a shareholders' agreement or agreement akin to it, rather than an employment contract. I agree. Mr Bartlett took us to the judgment of Mr Justice Newberg as it then was in Diamond. This was a case in which the claimant organised its business on a franchise basis. The franchise agreement contained restrictive covenants. Injunctive relief was obtained on the strength of evidence that the franchisee, who'd received extensive training from the claimant company, had covertly been running a parallel business in breach. The judge granted injunction and noted the comments of Lord Denning in office overload that where an agreement in questions of franchise agreement, it doesn't fall happily between employer and vendor purchaser. Having also noted that in Scully, the Court of Appeal decided that an employee restraint clause had to be subject to very rigorous and careful scrutiny and enforced only if it went no further than necessary, he went on, and then there's an expression, quote there that you've seen before, and then immediately after, indeed he went on to state that he found it difficult to see how it could seriously be argued that a period of 12 months could not be reasonable in the circumstances of the case. So that is quoted there with apparent authority from the Court of Appeal. So it's right that your lordships have that brought to your attention. So if we then, at this point, please, could we look at the case that we only managed to send over to your lordships yesterday? It's not in the bundle, but may I ask if your lordships have a copy of it? And that's the UKSC case of Harker Sinclair. So, Lords, first of all, my apologies that it wasn't previously noted by us, but I'm afraid it had slipped through our research net, so that's a matter to apologise to your lordships for, but we have it now. It is a very difficult, different type of case, because it's a case concerning, I think it's best to be summarised as an NDA and cooperation agreement between two solicitors hoping to put together a joint business running a class action.
Well, it's a class action in relation to the emissions.
It's
the first of what we are promised to have plenty of going forward.
Yes, it's the Volkswagen one, which I think was the first.
There's a whole load of them.
That we are, and as you all
Just transferred a lot of them out of Chancery into Queen's Bench.
yeah, and as your lordships will know, that they are all cases which depend on funding, and one of the issues in that case was access to funders. And that's how the cooperation agreement came into effect. So the only reason I mention that is because, as ever with these things, although the statements tend to follow one another from previous authorities, the context is not irrelevant. So may I invite you, please, to look with me to a few passages, starting on paragraph 63, which is internal page number 21. Bottom right hand corner. So if we can pick up just a few passages here. First line of paragraph 63, plainly there is no need for the legitimate interest to be spelt out or referred to in the contract. That I don't think is an issue between us, but I bring it to your attention. Then if we could go over the page, please, to page 22. There is a reference to the boxing case of Watson and Prager, which we have referred to in our skeleton and taken your lordships to very briefly today. Paragraph 65. Then, in contrast, Mr Crowe, Queen's Counsel for Harker Sinclair, relied on Watson and Prager, in which a contract between a boxer and his manager, who was also the promoter of nearly all his fights, was held to be an unreasonable restraint of trade. One reason for this was that the contract entitled the manager to exclude the boxer from any share of television receipts, thereby benefiting himself in his capacity as promoter. As it turned out, the purses received by the boxer were reasonable. As Justice Scott said, the reasonableness of a contract and restraint of trade must be tested not by reference to what the parties actually have done, but by the terms of the contract and what it entitles requires them to do. So that I think is, again, conventional. Paragraph 66, Mr Crowe further relied on coppage and safety new security. That's not a case that I think is before your lordships, in which a non-solicitation restrictive covenant and employment contract was held to be a reasonable restraint of trade and therefore unenforceable. In summarising the relevant principles, on reasonableness. Sir Bernard Ricks included the following at para 9 over the page. The question of reasonableness has to be asked at the outset of the contract looking forwards as a matter of the covenant's meaning and not in light of matters that have subsequently taken place, save to the extent that they throw any general light on what might have been fairly contemplated on a reasonable view of the clause's meaning. In that context, the validity of a clause is not to be tested by hypothetical matters which could fall within the clause's meaning as a matter of language, if such matters would be improbable or fall outside the parties' contemplation. And that, we respectfully submit, would be their joint contemplation. Paragraph 67, can I pick up the sentence?
Do we need all this recitation of the authorities? Because the conclusion is at 70, isn't it?
That's what the conclusion is, yes. But there are a couple
That's
of...
what matters, isn't it?
Well, there's a couple of passages I do want to bring your attention to as I walk through this, because what I said this morning, I made a number of, I think if I may say so, some fairly bold, you thought the bold submissions. I said I would pick them up in the review of the authorities, and I've just got one further review to do to make that good.
Mm-hmm.
So paragraph 67, line 6, in both cases, one issue was whether one should take into account in assessing the reasonableness of the restriction that the employee might be promoted. It was held that applying the obedicta of Lord Justice Diplock, one should indeed take into account because it was contemplated at the time the contract was made. Can I ask your lordships just to read through the quote from Bernard Livesey, Queen's Counsel, which is indented. So it's quite a long passage and you'll read it more quickly than I'll read it out. And then paragraph 39, if you would, on the same basis. If your lordships have reached the end of that, so I don't interrupt you. I do take from that some comfort, because it's the I've used the expression on a number of occasions this morning that these parties went into this agreement in the hope of it being a success, not in the hope of it being a failure. And here one sees precisely the same thing reflected. If we then look at paragraph 68, which is reference to Egon Zender, that's a reference to it at first instance. It says, Mr. Justice Mann said, that is not to say that one only looks at the actual position as the date of employment started. If one looked at that position alone, few covenants would be valid, because in most cases the employee will not have engaged fully enough with the business to justify it. One has to go further back and look at what was in the contemplation of the parties. Contemplation can include promotion. Now that's a promotion point, but here we draw some comfort from that, because this includes the process by which the franchisee is trained, introduced to the business, and given all the help and support and so on. And I've made those submissions, that whole package of benefits which are bestowed upon him by the franchisor. And then one sees it, and Lord Justice Arnoild is entirely correct, of course, to say that the final conclusion is in paragraph 70 on that question of law. Well, that was a question of law which was relevant to that case, but I wanted to introduce you to what had been said during the course of it along the way. Now, can I very quickly loop back to one other authority which we looked at this morning. And just take you please back to tab 3. And could we go back? This is Morris and Saxelby. I stopped, I think, at the foot of page 69. It may be relevant just to complete that by going to the top of page 70, that's the bundle number, 708 of the report. So this was the point was raised. It was suggested an argument that the interests of the public ought to be considered and weighed in determining whether a restraint is reasonable in the interests of the parties. I dissent from this view. It would indeed entirely destroy the value of Lord Norton's test of reasonableness. So I just wanted to bring your attention to that, as I had stopped short of that quote this morning, and I apologise for that.
So if you've concluded your review of the authorities, can I ask you a question?
Yes.
You referred to the Harker Sinclair, which was sent across yesterday. We were also sent yesterday some extracts from Chitty, and I want to ask you specifically about what is said in Chitty, and the passage starts at 18126.
Yeah.
But what I particularly want to ask you about is towards the end of that passage, because a series of criteria for application of the doctrine are set out, and there's 11 numbered criteria are examined. But the one I'm interested in is the last one, which actually turns out to be a group. So this is in 18134C.
I'm going to pay attention, if I may, without reading, because I haven't brought, by mistake, I've not brought the file with that in. But if your lordship...
Right, well, in 18134C, which is number 11 in the criteria listed, it says a range of factors should be taken into consideration. And there is then a quotation from the decision of this court in Quantum last year, Lady Justice Carr's judgment, and the 5 factors she sets out in the paragraph that's being quoted are A, the relevance of the consideration for the restraint, B, inequality of bargaining power, C, standard forms of contract, D, whether restraints operate during or post-contract, E, the surrounding circumstances, including the factual and contractual background. And you will appreciate that the one I'm interested in is B, inequality of bargaining power. So there is authority of this court in terms stating that inequality of bargaining power is a relevant factor to take into consideration in the application.
In determining the reasonableness, in other words, in determining the first limb of Lord McNaughton's test, and that's quite clear from Lady Justice Carr's judgment.
And she gets that from various early
And
authorities.
she cites, amongst other things, Schroeder and Macaulay, which you didn't show us in full, and Panayiotou, the George Michael case, Lord Justice, or Mr Justice Johnson Parker.
Well, insofar as that emerges from Macaulay, I'm afraid I did introduce Macaulay on the basis it was a different type of case.
Well, that, with respect, is tantamount to saying that categorisation trumps all.
Well,
because the whole thrust of the modern authorities is that categorisation isn't the answer. It depends upon all the circumstances of the particular case.
Well, Lord,
of course, the category into which it falls is one of those circumstances, but it's not the be-all and end-all.
Lord, I think I had said this morning that I myself wasn't wedded to the whole idea of saying that franchising was vendor-purchaser rather than employer-employee. So I'm not category wed, and I hope I'd made that clear, and I wasn't trying to suggest that this afternoon. But Lord, the basis of it, rather like the Boxers case, I rather see that as somewhat different as well. And I introduced Macaulay for very short purpose, really, but not because in my submission it really assists very much with a franchise case. So it's the in the I suppose I could call it the entertainment cases, if one's including George Michael as well with Tony Macaulay. In those cases, that there is a issue which confronts the court about inequality of bargaining when someone's selling up 20 years of their composer's rights or whatever it is going to be. In this particular case, we've got a different context, and in the context of this case, that is to say franchising, because of the nature of a franchise network, I stand by the proposition that for franchising, equality per se or inequality per se is not a relevant factor.
But then one has to ask oneself why. I mean, you're obviously right to say that the context we're concerned with here is different to the context in Schroeder and Macaulay and in the George Michael case. But why does context affect the principle? Because both in Schroeder and Macaulay and in George Michael, the courts were purporting to apply orthodox principles of the doctrine of restraint of trade. And there was nothing in either of those cases, or indeed in any of the other cases on this point, quantum again, same point, to say, well, we're applying some different principle. On the contrary, all of those authorities are applying the orthodox principles of restraint in trade. So why, as a matter of principle, do you say that inequality of bargaining power is irrelevant in our case?
It would be irrelevant in our case because if the court concludes, let me put it the other way, if the court concludes that absent that point, that is to say, some suggestion of inequality, come back to what I mean by that in a moment, this clause would be reasonable, and it would be reasonable to protect the covenantee, and that we're right in saying, which the authorities have said almost throughout, that that embraces the covenantor's interests as well, then there is nothing about the equality of arms point that would move to alter that decision. Because Mr. Bartlett wants to be a franchisee. He wants to be a franchisee of this franchisor. He's offered the terms upon which he may do so. He's given a copy of the contract in advance. And speaking for myself by way of submission, I would struggle to see why, if that is in the interests of those two parties commercially, it would fail the test if one simply said one was a larger party than the other. Now, that raises itself an interesting question, because there is in fact here no evidence of inequality per se. What we've got is which you would get in every single franchise case, is a professionally drafted franchise agreement offered by the franchisor. Leaving aside the judge's criticism of it for being 100 pages long, I think of one clause he described as prolix, I can't remember which it is, but he did. Leaving that to one side, was produced by a very respectable and experienced firm of London commercial solicitors, very experienced in franchising. There's nothing to suggest that Mr. Bartlett was not able to take advice on it. He was sent a copy of it in advance. He could have taken advice on it. There's no evidence that he couldn't afford to take advice on it. There's no finding that he couldn't afford to take advice on it. He did go and speak to his business manager at the bank. So he had I'm going to call it the independent franchise professional to speak to. So it's difficult to see what there is in and about the subject of inequality which is going to have any relevance to this question. So typically, there is always going to be inequality between a franchisor and a franchisee. It's very difficult to envision a circumstance in which there will not be. If you think of inequality of arms, because the franchisor is likely to be a larger business than a franchisee, even if the franchisee is already established somewhere. If it's a startup franchisee, that's pretty likely to be the position. So the reason I was so forthright as I was this morning is that in this context of franchising, it's very difficult to see how inequality of arms in that sense plays any part in the decision as to whether a clause is or is not enforceable. And bearing in mind that the factual points that I've made, that I'm not quite sure where the judge gets his inclusion of something which he's called inequality of arms. The fact that Dwyer is going to be a richer company than Mr. Bartlett is written at the start, but what's the relevance of that? There's no evidence that Mr. Mr Bartlett was unable to take advice. So, Lord, I hope that answers your question. If it does, all well and good. If it doesn't, your lordship will no doubt tell me, and perhaps you'll give me time to think about it overnight and come back tomorrow, as I haven't got the text in front of me, and that's my fault. But I think that's the answer to the question. So I suppose one might say, let's supposing I'm wrong about the submission that it's not a relevant factor, and it is a relevant factor. In other words, it's potentially there in the list of relevant factors. It's not actually a relevant factor that goes anywhere in the context of a franchise agreement. Lord, as we were on Harker Sinclair, I also was going to point out to you paragraphs 44 and 45, which I imagine your lordships may have read, but if you haven't, may I bring them to your attention?
Sorry, 44 and 45 what?
Of Harker Sinclair, internal page 15, Lord. So the reason I thought this may be of interest to your lordships is because there is a question posed in paragraph 44 and 45 principally, as to whether Patel and Mercer's got any relevance to your lordship's decision or to this area of the law. And paragraph 45 sets out the decision of the court. Just to remind your lordships, that was Lord Lloyd Jones.
So basically, we don't need to worry about Patel and Mercer.
Yes, and the only which is good news. Well, the only reason I suddenly realised I hadn't taken it to you, but I thought I ought to, is because when you introduced the passage from Chitty, you did use the expression range of factors, and it rather triggered my memory at that point as to whether I should be bringing to your attention the sort of Patel and Mercer point, and we had taken that in our skeleton argument. We referred to it, as you might remember, and said we didn't think it was relevant at all. I can explore more with you why we don't think it's relevant if you want me to, but unless you do, I will just take it that your lordships may be persuaded by paragraph 45 of Harker Sinclair. Perhaps I can leave it on the basis that if your lordships have any questions about it overnight, I'll happily talk about Patel and Mercer in the morning, or if it arises through anything the respondents say, similarly I can deal with it in reply. But for the moment, I rest on.
I'm content to leave it on one side.
Yeah,
Quite.
Lord, I too. I think I respectfully submit that it's a very different part of Chapter 18 and Chitty, and not directly relevant to this. So, Lords, before I come to make some closing submissions, may I just take you back to the paragraph 108 of the judgment. I'm not going to ask you to look at it immediately, but would your lordships just indulge me and go please to the supplemental bundle, if you have that easily available. Could we go please to tab 11 of that? And by way of introduction to paragraph 13, I'm going to give your lordship some dates which may not be immediately apparent to you from the judgment. The first is that, as we know, the agreement was signed on the 4th of August. I'm sorry, I beg your pardon, 4th of October, of course. Then that was followed by a 12-week training programme, which had a name, Sure Start, after which the franchisee started trading in, I think, the second week in January. Now, Lord, were you to compare paragraph 13 with, in this witness statement, which is Mr. Jean's witness statement, with paragraph 108 of the judgment, your Lordship will immediately see that one is derived from the other. So the words, and it's clear from the top of page 57 in our bundle, the words here quoted are Mr. Jean's evidence in chief, in other words, his adopted witness statement. Paragraph 13 is that witness statement, and that's the passage from which it follows.
And it supports the judge's finding, doesn't it? Because he says, I had met him on a number of occasions, both by telephone and face-to-face, including the orientation day on 28th September, so that's before signing the contract, and during training. So that's after. Struck me someone overactive, tends to be easily agitated. And then in the last sentence, he says, my witnessing of Mr. Bartlett's behaviour, both prior to him starting trading and in my dealings with him thereafter, was he was needy, prone to agitation, difficult building relationships, including with customers. So this is covering both before and after execution of the franchise agreement.
It is, and I was happy to concede that this morning. But when you look at the full text of paragraph 13, I'm not going back over that concession. When you look at the full text of paragraph 13, there was one orientation day on the 28th of September, and then what we get is concern expressed by Mr. Jean towards the end of the programme. So the relevant references to him being anxious and requiring extra support and so on and so forth are all towards the end of the programme. So that's before he started trading, but after he'd signed up. So what I wanted your Lordships to have, and I'm doing nothing more than putting it in its context, so please don't think I'm trying to reverse out of what I said this morning, because I'm not. I just wanted your Lordships to have the full context of what is a redacted version of a longer paragraph. So I'll leave that with you, say no more about it, but your Lordships may or may not think on reflection that it's right to base everything simply on the redactions, or the redacted paragraph. So, Lord, I have, subject only to anything else flowing from Patel overnight, or anything that emerges from me looking at the 2 points Lord Justice Arnold has asked me about this afternoon, and I'm going to accept an invitation to address those tomorrow morning. I now want to make, if I may, some final submissions. So I'm going to try and pull this all together and see where it goes. So we respectfully submit that the following points are established by what is said in the authorities we've taken you to. The exercise is concerned with looking at the date of the contract. It looks to see if the covenantee has a legitimate interest to protect. And I think it's common ground in this case that it does, and the judge accepted that. It looks to see what the restriction is, clause 18, and whether that restriction is no greater than is reasonable to protect that interest. That interest is a basket of interests, but including the proposition that if a franchisee leaves, the franchisor will wish to replace them. That involves identification, recruitment, onboarding, training, establishment and installation and so on, to give them a fair run, as one of the cases said. And therefore it is that interest primarily, amongst others, that interest that the restriction is there to protect. I'm not going to repeat here, but your Lordships, I hope, keep in mind the wider context of franchising and how the franchisor's goodwill is established not only by what they do, but what all other franchisees do and how much the other franchisees pay and so on and so forth. The next point is that the exercise does not consider the particular characteristics of the covenantor for the purposes of working out reasonableness. Because the law and the cases I've taken you to have uniformly stated where this question has been addressed that there is a concomitant interest in the covenantor aligned with the interests of the covenantee because they are entering into this symbiotic commercial trading relationship. And that makes particular sense in a franchising context. The court does not consider the consideration paid for the deal or the proportionality points, but the wider context of what is included in the contract is a matter for discussion because it's the, as it were, the reason why the alignment of the covenantor's interest it lines up with the covenantee's interest because it's what the covenantor is contracting to obtain from the covenantee. And that includes everything from the benefit of investment, the marketing, the promotion, the goodwill, the name, the training, and the business systems and model and the business manual. It includes all that. Finally, one assesses what objectively is contemplated by the contract. That, as we've seen, includes what might be the position in due course. So in other words, the promotion to partnership of the employee employed by a solicitor. Not guaranteed, might happen. So here we've got, I've banged this drum more than once during the course of the day, what ought to be an objective assessment that there were two contractual parties entering into an agreement in the hope that it would be successful, not in the hope that it would fail. There's the next point that if one focuses, and that was the very last point I took you to, penultimate point I took you in Harker Sinclair, that if you look only at the restriction on day one, it's very likely that you would conclude that the restriction's too great. What you have to do is to take into account what's contemplated by the contract. So those are the key building blocks we respectfully submit that should go to the assessment of reasonableness. If we then compare that with the trial judge's judgment, going back to paragraph 305, we find that that is, with respect to him, not on the face of it an exercise he's done. I was asked some questions about that this morning, and I've thought about it over the short judgment, and I stand by what I've said, and can I try and explain why I've said what I've said about it? It is quite right that the judge talks about Dynarob chips away, Colquick, and the need to replace or desire to replace a franchisee. So on the face of it, I've crossed those hurdles. But there is nothing in paragraph 305 which actually addresses, with the greatest respect, why the restriction then extends beyond what is reasonable in order to achieve the protection that it's designed to achieve. So let me, I'm going to stick with something close to our original groupings in our skeleton, a little bit different. But if one looks at A to D can be summarised as having the following points in them, and only these points: inequality of arms, no negotiation, Fredbar was a start-up and Mr Bartlett had no previous experience of drainage. There was a risk that he may not obtain the projections, financial projections. He was investing all of his savings with at least some possibility that if it all went wrong, he may be financially disadvantaged or even out of his home. Now, with great respect, absolutely none of those, barring the equality of arms point if the challenge from Lord Justice Arnoild is one that I can't meet, none of those are relevant to the question of the reasonable protection afforded by the clause. And if my answer to Lord Justice Arnoild persuades him that what I've said is good enough, then I can say that none of them do. So, with respect, A to D don't really go anywhere at all. I just want to then go on to E, because E falls into two parts. The first part is something that I have to say, speaking for myself, simply never heard before argued. I've never seen it in a judgment, and I'm not aware that there is anything judicially that would support it. Now, that doesn't make it bad, but I can't find anything for it. So what is being said is that taking the trial judge's joint and several approach, whether he's right or wrong about that is for your lordships to say, but taking that approach to paragraph 305, he is saying a sole reason, standalone reason, for this being an unreasonable covenant is that it does not include a statement that it can be disapplied by consent, such consent not to be unreasonably withheld. That, with the greatest respect to him, cannot conceivably be right. And if one simply stands back from it, how on earth, if I can put that colloquially, how on earth would a court deal with that if someone applied for an injunction in circumstances where the departing franchisee had asked for consent and the franchisor would reject it? Because one comes back to the basic proposition. If I'm right about paragraphs A to D, if I'm wrong about paragraphs A to D and I've already lost by the time we get to E, then this point is in a sense slightly irrelevant. But if I'm right about A to D, what would there be for the court to consider? So a request from the franchisee that he be allowed to compete to the disadvantage of the franchisor post-termination.
Well, so because two relevant factors that might be relied upon in that context are, I'm not going to a competing business, I'm going to one that is at best similar because it doesn't do emergency plumbing, point one. Point two, we're only 6 months into the 10-year term. That is surely a different scenario to if he's going to a directly competing business and you're near the end of the 10-year term. Well,
there might well be things one could look at, but I'm addressing this in relation through the lens for the moment of A to D. Now that may be inappropriate, but if were he to rely for the purposes of consent on anything within A to D, then I would respectfully submit that what's said in E can't possibly be right. So if And I have never ever seen a suggestion argued or found, I may be wrong, but I can't recall ever having seen it, where someone has suggested that a restraint of trade clause is per se unreasonable unless it includes an escape provision of consent not to be unreasonably withheld.
I think I may be wrong, but I think there is authority for the proposition that one of the ways in which restraint of trade clauses can be, as it were, saved from being unreasonable is if they contain a provision of this kind.
I can't. I have no recollection of it.
Well, the only place I can think I've seen is somewhere in the passage from Chitty, which I did actually read.
I'll look again, but I haven't. I have no experience of it. I'm not saying that that's determinative of
but if you think about it as a matter of first principle, then it's obviously got it doesn't seem to me there's anything at all surprising in the proposition, because it encompasses exactly the sort of points my lord has mentioned. There might be any number of other points that might be made, which bear on the particular factual circumstances and enable a more flexible approach than the one which you advocate.
Well, there are two answers to that. One I've already given, but the second answer would be, for example, whether the court retains a discretion as to the granting of an injunction, which it plainly does. So where the court has policing power here is not whether there's going to be a breach of the covenant, because there may well be. And if there is a breach of the covenant, then if any damages flow from it, that would be one thing. But the sorts of points that Justice Arnoild have mentioned, and your Lordship just mentioned, would reflect themselves in what would be an equitable and discretionary application by the court of what it would do if it was invited to injunct somebody from carrying on a breach of contract. So that in and of itself wouldn't go to whether you need the escape clause of the original contract. If the court's thinking that it would like, and I quite understand why your Lordship thinks that might be a good idea, would like some mechanism for ensuring if you were asked to put the franchisee out of business by injuncting it, the answer to that is you can deal with that straightforwardly, because no one is entitled to an injunction. They might be entitled to damages, but they're not entitled to an injunction. It's very much a court discretionary point.
Well, I see that point, but you were suggesting that a clause in this form would be unworkable, because I'm sure you're aware it's absolutely routine in the context of landlord and tenant.
Yeah.
And the courts apply the test all the time. County courts up and down the land every day.
They do, yeah. But the difficulty, I quite understand that, and a long time since I've done a landlord and tenant, but yes, it's routine in that, and that I understand. But the question here is that if there is a breach of, I think it's, again, looking at it, if I may say so, the wrong way round. If the restriction is reasonable, and it's reasonable at the date the contract is entered into, then the point Lord Justice Arnold puts to me about what's happened and what period of time has elapsed should not apply, because what we're actually looking at is the reasonableness of the restriction at the time it is entered into. And if that is reasonable at the time it's entered into, then it's reasonable. That really is the point.
Well, so I can understand that in a situation like this, the reasonableness of the restriction is likely to increase over time. But surely it's a mistake to argue that backwards and say, well, because it would be reasonable in the last year, the 10th year, therefore it's reasonable in the first year. That doesn't follow, does it?
No, because the assumption is that it's that way round. It might very well be reasonable in the first year because of the training, the knowledge of the intimate knowledge of the business model and everything else. And it may be underpowered in year 10. So I quite understand, but learned friend is trying to support the concept in the second half of this paragraph about a sliding scale of restrictions. You know what we've said about that in the skeleton. We respectfully disagree with it. We think it's wrong. But the assumption behind the need for a sliding scale is that the restriction that's put in the contract is a restriction which per se does not apply until year 10, or year 7, or year 8, or wherever this mythical time would come. And the difficulty with the tiers is that, again, one is faced with a really, I respectfully submit, difficult and unworkable scenario. So let me, if I may, move on to sliding scale, because it's in the same paragraph. So I hazard the judge had it in his mind as being part and parcel of the same exercise. I may be wrong about that, but it reads as if it was. The problem with the sliding scale is at what point and based on what criteria should the alleged upgrading of the restriction be measured? So is it simply length of service? But then, if it's length of service, how does that work in circumstances where there's a pandemic for 2 years or something else for 2 years and the market drops and really where one expected someone to be after 3 years, they're not there until after 6 years? That is all looking at the wrong thing. It's trying to create a policing mechanism for a restraint over a 10-year period. So let's suppose, for example, the franchisee is far more successful than anyone anticipated and achieves double or triple revenue in year 2. Are we then to have a sliding scale the other way, with not a consent not to be unreasonably withheld to reduce the term, but a consent not to be unreasonably withheld to increase the term? It would be totally logical to do that. But what one would be trying to bite off here would be something which is almost impossible for anybody to draft in advance or police in arrears. And in terms of restraints, just let me bite the bullet with employment restraints. Employment restraints are normally 3 months, 6 months, 12 months, depending precisely on the nature of the employment. Sliding scale restraints, I don't think I've ever seen. Now, I may be wrong about that, but we've not found one. We have not found, I think, one example where the court has been asked to consider sliding scale restraints on restrictive trade. And at the moment, it's difficult to discern what in principle that would be seeking to achieve or why it's right. Because there are many circumstances in which a covenantor can become a menace to the covenantee very quickly, or never become a menace to the covenantee. But the point about that is that you have to take a view at the date the contract is entered into as to what would be reasonable protection. So that's what I want to say about E. I'll say more about it if your lordships want me to, but we've said what we've said in the skeleton and you've read it, and it's in a sense a very visceral point. We're either right or we're wrong. F. And really, it seems to us that we can group. Let me do another group for you. We can really group F and G and probably J as being pretty standard policing mechanisms. So, leaving aside for the moment Lord Justice Arnold's point about suitable, which will fall within ground 2, if I'm wrong about ground 1. I've already taken you to decent and fairly well established authority, I think in 2 cases, where having a simple non-solicitation clause would be impractical to police. And that is why all covenantees draft restraint clauses, so that they catch, being blunt about it, clever ways entered into by covenantors of setting themselves up in a way that would otherwise be a breach of covenant, but falling strictly outside the restriction. So that is why you have expressions such as, for example, engaged, concerned or interested in, because it's intended to cover the wide variety of ways in which somebody may try and escape restriction. It's designed to stop clever future employers or business partners setting up structures which allow there to be the very breach and the very competition that the clause is designed to prevent. So every clause that one sees conventionally, and that would include employment restrictions as well as commercial restrictions, are always set up on the basis of having policing clauses. And the ones that the criticisms made by this judge at the trial of those clauses, leaving aside Lord Justice Arnold's suitable point for the moment. Similar, I'm sorry, you're quite right. Similar point for the moment. I'll come back to that, but I've said what I've said about it so far. Is that these are pretty plain vanilla, well-established expressions designed to catch not a width of activity outside competition, but designed to catch different ways of setting up.
One of the points the judge is making here, for example, he says, Mr Bartlett could not be employed by a plumbing or drainage company. So an existing competitor to your clients within the exclusive marketing territory, he can't go and be employed by them.
Well, but if the purpose of that employment was in fact for him to go and take to the competitor under the guise of an employment contract what he had learned about Fredbar Dwyer's systems, what he'd learned about their customers, what he'd learned about their pricing, absolutely right that he should then be restricted from taking employment, the purpose of which was to...
Well, there's nothing in this judgment about pricing, is there?
No.
So
No,
it suggested that was a trade secret.
No, they're not trade secret points, but the point is the way in which a business is structured and the way it prices itself, the way it puts together prices for clients, the way it promotes itself and the way it runs its business internally. So what I've described as the business system and the manual.
But I would understand that if your clients had some form of trade secrets in the way they ran the business.
The judge has said in terms that this wasn't a case where there was an issue about.
Well, we've never argued trade secrets.
No.
What I'm saying is here is it's a question of whether the use of that information could disadvantage or be put to try to disadvantage an incoming franchisee. It doesn't have to be a trade secret to do that. It just happens to be something that the competitors don't know about. Now, in due course, they may know about it, but they will know about it at a time when the incoming franchisee has been given a level playing field run, not before. So we come back, I'm sorry, it seems as if I've got the record's rather stuck, but we do come back to the same basic propositions. That what this is designed to do, and what in our respectful submission it does and no more, is to prevent and police competition for a reasonable period of time throughout the lifetime of the agreement to give the franchisor the opportunity to protect its goodwill, maintain its investment, get its money back on its investment, and to do so with a new franchisee. That's all it's designed to do. Now, the policing clause would well stop somebody being an employee or a partner or a subcontractor. And so it should, if in fact that is to stop the unfair and inappropriate competition. The assumption behind Lord Justice Arnold's question to me, I think, is that the employee would be somebody who goes in only as an employee, just being told what to do, turning up and rodding someone's drains.
It includes that. I take your point that it might include something else, but it includes simply being the contractor who goes out and does the job.
but it has to if the clause is to be policed, because otherwise, if we're right that non-solicitation alone is impractical, then it will always be said, oh yes, he was at Mrs. Smith's last Thursday, but had nothing to do with him. We just sent him there. So what a franchisor or a covenantee will never find out is how that job was won. That's the type of competition that it is appropriate.
But your client's business is emergency plumbing, and there's little repeat business. So I don't see how this works. I mean, I take your point. You've got a very fair point to say this is all to give the incoming franchisee a clear run. I understand that. I take that point. But you then have to view that in the context of, on the one hand, what's the nature of the goodwill? Answer, it's goodwill in an emergency business where there's little repeat business. Okay, you've got the national accounts, I understand that, but apart from that, there's essentially no repeat business. And then you've got the extent of the clause, which is it prevents the individual, here Mr Bartlett, going off and being a mere contractor for an established competitor.
Well, I don't want to give evidence. Maybe I've had bad luck, but actually repeat plumbing requirements has not been something for me that's been unfamiliar. Yeah, so, Lord, I'm not trying to make light of your question.
Of course, a householder can have more than one emergency during the course of their tenure.
Or they could move. They could move to another house, but they're still the same person with the same contact. So the reason that solicitation is such a difficult concept for covenantees to manage, and why policing provisions are routinely acceptable and upheld, is precisely for that sort of point. So Lord, I wasn't trying to make light of the point you were putting to me. What I'm saying is that I'm not sure that one can deduce from this judgment a positive assertion that it's a non-repeat business. I'd be speaking for myself, quite surprised if that was so. So, and of course, it's not only drainage, it's plumbing as well, which is more likely to produce repeat business. So there it is. That's what we say in principle then about that group of objections. And I think that really rather deals with it. We've got the buffer zone, and I've already given your lordships along the way, so it's a short point really. Because the territory is not absolute and cannot by law be absolute, because of competition restraints, a buffer is appropriate. It doesn't make it inappropriate because it may not have happened by the time the termination came to an end, because that's not the correct way to look at it. It's the wrong end of the telescope. And in any event, the buffer is in a self-standing clause. So I know I'm mixing ground 1 with ground 2, but it's an easy mix to do at this stage. If we're wrong about that point, we would strike down subclause 2. That's not even a blue pencil test. It's 2 clauses, and one of them survives and one doesn't. So that, on the face of it, is I think a very short point in this case. And I'm not sure there is anything else of substance which actually then exists. So, for example, little k, there was no reciprocity to be applied should the claimant have committed a repudiatory breach. Because I'm not sure I entirely understand that. If the law through other means is going to say that a covenantee in repudiatory breach can't enforce a covenant, well, a law can say that. If the law permits a covenantee to enforce a covenant, even though the covenantee for other reasons is in repudiatory breach, then it's entitled to the protection. Its repudiatory breach simply means that there's a claim for damages against it. So I can't, at the moment, I can't see what case doing here, and I can't see what function it performs. We don't question that there are no trade secrets to be protected. So there it is. That's what we say, I think, about ground 1. There are 1 or 2 points your lordships have asked me to come back on, or given me permission to come back on tomorrow morning. which I will do. So that then leaves me with any other ground 2 blue pencil points. And really these fall into a very simple compass. So similar to is 1. I suppose what would have to go would be similar to or would be those 3 words. But that can be very easily blue penciled if your lordships were to conclude that was offensive. Engaged, concerned or interested in is pretty standard vanilla stuff to police. But if your lordships were troubled by any part of that, you could blue pencil 1 or 2 of those words as well. I don't at the moment understand why it's said by the respondents in their skeleton that they can't be blue penciled. They plainly can. We're not suggesting rewriting. Understand that's completely no good. Not even going to go there for that. That can't be right. But I don't see the difficulty with dealing with it on the basis that we say. So that only then leaves the respondents' notice points, I think. And I don't think I really need to say very much about it. I'm happy to leave this for reply if your lordships think that's appropriate.
I'd have thought that's the best, Mr Jones.
Pardon, Lord, I didn't hear. I'm so sorry.
I said it's probably better if you leave that to reply.
If your lordships are comfortable with that, then I would prefer to.
Yeah. I think we'd quite like to hear from Mr Grant.
So, Lord, unless your lordships have any questions, I have said what I want to say.
Thank you very much.
Thank you very much indeed.
Good afternoon, my lord, my lords, my lady. I anticipate being in the region of 2 hours, which means that we won't finish today.
Well, we didn't think we'd finish today.
No, and I will seek to improve upon that. But that is...
Don't feel rushed.
No, that is the best estimate I can give at the moment, my lord. May I start with a few preliminary points? And first of all, obviously, I have with me my learned junior. I do not have Mr Bartlett in court. He's watching by the live link. I understand there's a 90-second delay. That won't trouble us today.
No.
I'll seek to accommodate that when I come towards the end of my submissions tomorrow, in order for Mr Bartlett to provide comments as he has done indeed this morning.
Right. Well, we appreciate, Mr Grant, the difficulty under which you labour, and I'm sorry there's a 90-second delay, but
no, but that is what it is. And again, Mr Bartlett
just the way it is.
has asked. He's very keen for it to appear that he isn't here out of any discourtesy. And
No,
I'm
no,
sure that that's not the position.
We don't. We wouldn't think that in any event.
One other preliminary point, it's implicit in what my learned friend has said, and particularly what he hasn't said, that ground 3 is no longer being pursued. Yeah. So I should say no more about that. Mm-hmm. In terms of the structure of my submissions, I want to first of all deal with a few other introductory points, partly picking up the factual inquiries which the court has raised this morning. Secondly, I want to summarise the factual situation as it was on the 4th of October 2018. Then I shall turn to the legal approach. That really deals with the respondent's notice ground 1, which is what is the appropriate test in a case like this. And then I shall turn to ground 1 of the appeal, which also incorporates ground 3 of the respondent's notice. Then deal with ground 2 of the appeal, the blue pencil point, which hopefully can be taken shortly. And finally deal with my ground 2 of the respondent's notice, which is also a blue pencil point.
Yeah. Good.
In terms of some of the factual points, perhaps I can deal with these now before I get into the substance of my submissions. It is Mr. Jean, I think he's South African, is the pronunciation. His job title was managing director, but he wasn't an officer of the company. And I will take in due course to paragraphs 49 and 50 of the judgment, which pertain to Mr. Jean. My Lord the Chancellor asked the question this morning as to other neighbouring franchisees. The best research that my learned junior and I have managed over the short adjournment is this, that the nearest franchisee was in Avonmouth. That's to be found at paragraph 23 of the defence, which is in the supplemental bundle. sorry, it's in the core bundle even, I do apologise.
Yeah,
Core
it's in
bundle,
the-
paragraph 23, bear with me for a moment.
Yeah, sorry, Mr Grant, it's
Not at all.
defence, paragraph.
So it's tab 8, page, I suspect, 118 of the bundle, it's the core bundle. Paragraph 123. You can see there, C has a franchisee in Avonmouth covering D1, D2's old EMT, exclusive marketing territory.
Yeah.
So, in terms of searching other things, there's nothing else that appears in the material before the court.
No. Well,
That said-
Avonmouth is closer to Cardiff than Gloucester.
Yes, so that's the closest. In terms of the immediately neighbouring ones, Swansea, Newport, and I think it would be Pembrokeshire, there was an email in the trial bundle, which is not before this court, but hopefully it is helpful to say so, that all those territories were vacant at all material times. And that doubtless is partly why Mr Bartlett was entitled to go to at least one of those neighbouring territories during the currency of the franchise agreement. Had there been a franchisee there, one assumes that they would have had first pick over the work. So we will renew our inquiries over
Don't
night,
sound worried
but
too
that's
much.
as best as we can
Get
do at the
general
moment.
gist.
My lord, I'm not going to speak to the court about franchisees generally. I'm going to focus on the specifics of this agreement for reasons which I hope will be obvious, save to make a couple of introductory points. As the court has doubtless determined, franchisees can be, or franchises can be of a number of sorts. They can be service franchises, which is what we had here, production franchises, and distribution franchises. Also, the franchisee can either be the individual providing the actual service, etc., as was the case here, as we'll see, or it can be a management franchise, where the individual who is the franchisee has a fleet of people working under him or her, or perhaps it's a limited company doing that. Franchisees may well be inexperienced, uninformed, and lacking in bargaining power, and I've included in the authorities bundle an extract from the Franchise Law Review to that effect.
Yeah.
But it's effectively acknowledged by what my learned friend said this afternoon. My learned friend said a couple of points that individuals within the claimant organisation were BMA qualified. That may be true, but it doesn't go very far. And if I can ask the court to turn to the judgment, whether within the bundle at tab 5 or loose in the Chancellor's case, turn to paragraphs 49 and 50. I can ask the court to read it for yourselves. That explains the position of Mr. Jean, what his role was. And I also refer to 49 in terms of his status and role, paragraph 50 in terms of his familiarity or lack thereof with certain matters pertaining to franchising.
Sorry, with great respect, I'm only rising because if I've misspoken, so be it. But the only person I said was a BFA qualified professional.
Was Mrs Brunton.
Was
Yes,
Mrs Brunton,
Mrs.
which
Brunton.
is paragraph 46.
And I don't want to interrupt my learned friend, but he introduced this part by saying I said a couple of people were. I don't think I did. It was only her.
Right, well, anyways, not much will turn on it. Right.
Yes, thank you. And the final point in terms of franchises is that, at least within the UK, it is not subject to regulation, a point which the judge observed. That is simply for background only. In terms of the facts as appeared at the date of the entering into the franchise agreement, there's a very good summary of paragraphs 3 to 4 of the judgment, which you've seen already, which sets out the position of the claimant company, professing to be the largest company of its sort within the United Kingdom, and the disparity with the position of the defendants. I'm going to take the court through several aspects of the judgment under the following headings. First of all, the inequality of the financial clout and bargaining power. Secondly, that there was no scope for negotiation of the franchise agreement. Thirdly, that the defendants had no experience in plumbing, that Mr Bartlett would be undertaking it personally. Fourthly, there would be a need for Mr Bartlett for initial and ongoing significant investment. Fifthly, there was a risk of failure. And sixthly, that this would be a case of growing the franchise from nothing, there being no previous franchisee for some period of time. Now, much of this we've covered, so I'll take it as quickly as I can. But in terms of the first point, in the part A of the first point, the claimant size, so that's covered in paragraph 3 of the judgment. The number of franchisees covering the territories, the fact it's the largest full-service emergency plumbing and draining company, and that Neighbourly was the group as the world's largest home services franchise group. We have the financial information, all of which is borne out by witness evidence in support of the claim, but it's there in the judgment. By contrast, the position of the defendants appears at paragraph 4 of the judgment. He was, at the time, Mr Bartlett was, at the time of entering into the franchise agreement, effectively a near assetless novice. And in fact, my learned friend used the phrase this afternoon of a start-up franchisee. He had no prior experience of plumbing or drainage. And we've already looked at the point of paragraph 108 of the judgment, quoting from Mr John's third statement, where Mr John knew that he required more support and hand-holding than others. Another important factor is the claimant was fully aware that Mr Bartlett was going to be doing the plumbing himself. See paragraph 90 of the judgment to that effect. The final point in terms of the defendant's experience pertains to the training which was offered. And one of the points which my learned friend has said repeatedly during his submissions today is look at what the claimant was giving. He's referred to a manual, which I'll turn to later, training, marketing and the like. I'm going to take each of those in due course throughout this part of the submissions. In terms of training, the judgment records at 78 that it was clear that Mr Bartlett needed training. And at paragraph 143 of the judgment, the judge notes the evidence from the claimants that Mr Bartlett undertook a 2-day plumbing course. He was to be engaged, according to Mr Jean in his first statement, paragraph 56, page 60 of the supplemental bundle, a 2-day basic plumbing course, and he was to be engaged in basic plumbing. Now this is relevant for a number of reasons. It goes to whether there are any trade secrets or other specialities pertaining to the claimant's business or the plumbing business which any franchisee was going to be carrying out. And to highlight what I'll be saying in due course, the answer is quite simply no. The greatest respect to the claimant, the business being undertaken by the franchisees was an entirely unexceptional plumbing and drainage business. The evidence was that there were perhaps 12 or 15 other people in Cardiff. Undoubtedly, the answer will be in excess of that. Nothing peculiar about the way in which the plumbing and the draining was carried out. Nothing peculiar about the business methods which were done. We've heard repeated reference about the manual. The manual wasn't in evidence before the judge. And I say that you should completely disregard it. The judgment notes that it was criticised by Mr Bartlett, but the important point was that it wasn't before the court. Moving on to the need for considerable upfront and ongoing investment, one sees references to that throughout the judgment, and I'll take them as quickly as I can. Paragraph 4 reflects the fact that a hire van would be required. This is something that Mr Bartlett and his company had to hire on a lease basis. Paragraph 13 of the judgment records the fact that the initial franchise fee was £35,000 plus VAT, i.e. £42,000. There would also be a weekly MSF, management service fee, which I'll come to in due course. There are other references in the judgment, paragraph 101, to initial fee of £24,500. Mr Jean, in his witness statements, makes reference to the various sums that had to be paid, but the best place to look at is the judgment, paragraph 101. Paragraph 85 of the judgment is important, and I will ask the court to look at that. We've already touched on paragraph 86 already. This is the self-assessment report, and I say that that is significant in detailing the circumstances of Mr Bartlett who incorporated the first defendant solely for the purpose of entering into this franchise. Paragraphs 85 and 86, which you've already looked at, detail, in considerable detail, the specifics pertaining to Mr Bartlett at the time of entering into the agreement. If the court is content to move on, over the page, paragraph 89 of the judgment summarises again the position, the franchise fee, and then also commitment to pay during the term monthly royalty fees of 15% of turnover and an advertising and marketing levy of 2% of turnover. There's a question of national accounts work, which the court has understood. That is slightly different from Mrs Smith in a terrace calling for emergency plumbing. These are institutional clients with repeat work. The example given most repeatedly during the trial was of J.D. Wetherspoons. Other national account clients were University of Cardiff from recollection. These are people from whom the most regular source of repeat work is going to come. These are the people whom the franchisor really provides for the franchisee. But in this case, because there had been no franchisee operating in the Cardiff territory for some time, Mr John said because we'd had no one servicing the national account work for 18 months, it was going to take time for that work to pick up. I'll give you the reference for that in due course. In fact, now is perhaps a convenient time. If I can ask the court to look at the supplemental bundle, I'll take you to 3 specific references as quickly as I can. First of all, it's the first statement of Mr Jean, tab 8 even, page 52. This is a paragraph 30 broken down to various subparagraphs. It's E, which is of particular interest. Reference first of all to national accounts, but then it's third line down, the new sentence beginning at the end by the top punch hole. The Cardiff territory had not been operated by a franchisee of the claimant for several years, and it would take some time for national account work to build up in the area. And while we're on it, subparagraph F.
Sorry, Mr. Grant, I was just taking a note. That's paragraph E, yes.
Yes, so it's paragraph 30, subparagraph E.
Yeah. Yeah.
That's the first reference. Then staying within this bundle, turn to tab 11. This is the third witness statement of Mr Jean. Page 97, paragraph 34. This is the evidence I spoke to a few moments ago. Second line, we had not been able to service those national accounts for 18 months, and they would have to find other suppliers. We therefore needed to try to win them back to Drain
must be
Doctor.
on the wrong page. Could you give me the page again?
I am sorry, my lord. It's bundle page 97, I think as my lady said.
Thank you.
Tab 11, page 97, paragraph 34. Second line, last 2 words, new sentence beginning, we had not been able to service.
Yeah.
Yeah.
So everything my learned friend says this morning about existing goodwill needs with the greatest respect to be treated with a pinch of salt. There had been no existing franchisee in the area. National account work was not guaranteed and would have to be won back. There was a big onus on the franchisee, in this case the defendants, to win work. This wasn't the case of the defendants purchasing the franchise from an outgoing franchisee, which would be a very different situation and would be more akin to the vendor-purchaser cases upon which my then friend places so much reliance. Back to the judgment, if I may, put away a supplemental bundle for the time being. Paragraphs 97C and 99 detail again the financial position is set out in the various projections which were provided to the defendants. Just to pick out a few points of particular interest. Top of page 54 of the bundle, so this is 97C of the judgment. The franchisee's required starting capital was £80,000. We don't need to go into the rest of that detail in that paragraph. While we're on that page, page 98 details the national account work being described by the claimant's witnesses as being the cherry on top. In other words, not guaranteed, but a welcome bonus. Over the page, sorry, page 99, which straddles this page and the next page, the top of page 55 references the 20,000 together with a further 90,000 which he would have had to borrow. The precise figures vary in time, but the important point to take away from this is the amount of investment required by the defendants for dealing with a standing start and given their lack of assets. Paragraph 104 of the judgment details the fact that Mr Bartlett sought a loan from National Westminster Bank. To that extent, he had a bank manager. It is being suggested by my own friend that the bank manager offered him financial advice, let alone legal advice. That's simply not the case. But there was a loan, and we can see within there again, Mr Bartlett's personal funds being recorded as being £20,000. So returning to one of the questions posed by my Lord Justice Arnold this morning as to why all franchisees should be treated equally, they shouldn't be, and they're not. And the specifics of Mr Bartlett are a world away from someone else coming in as a management franchisee with 4 vans at his disposal and a number of employees or subcontractors under him. This couldn't be further from that. Another point worth bearing in mind is paragraph 100, still on the same page. The court may pick this up already. With it on or about 6th of September 2018, Mr Bartlett decided not to proceed, really because of cost implications. So while my learned friend says that he set out to succeed, that's undoubtedly true, but there was a very real doubt in his mind as to whether he would. He was assuaged to no little degree by the claimants. And while everyone sets out to be a success, there was a clear risk of failure, in this case at least. Leads me to my next subheading, the risk of or potential for failure. So I've mentioned the fact that there was no existing franchisee in Cardiff, so no existing goodwill. There had only been 2 resales of franchises since 2015. That's apparent from the judgment at paragraph 77. I apologise for requiring the court to turn back a few pages. Bundle page 50, paragraph 77. This is the evidence of Mr Jean. This is useful for reasons I'll come on to much later in my submissions. At least 25 new franchise agreements and resales, 2 in 2015, sorry, I do apologise, 2 in 2017, and 1 in 2018, 1 in 2019, and 1 in 2020. So nonetheless, the point is that the number of resales was much, much smaller than the number of new territories which had been granted, either in virgin territories or franchisees which had lain fallow for some time. Also known to the claimant was the fact that 2 recent starters had ended very shortly afterwards. This is in the 3rd witness statement of Mr Jean. I'm afraid I require you to go back to the supplemental bundle. So supplementary bundle, tab 6. Sorry, it's not, it's tab 11. 3rd witness statement of Mr Jean. Paragraph 6, the bottom of page 88. So we want 2 examples of franchises which started about the same time, which didn't last very long at all. Mr Jean says neither was representative of the network or useful as a comparator for new starters, but in my submission was a significant point. returning by me to the judgment itself, the judgment records at paragraph 101E that cash flow would be tight. That was also confirmed at paragraph 111. Paragraph 155 this deals with the fact that the claimant's proposed prices were at a premium rate. This was something the claimant made a virtue of when applying for the injunction, and that evidence was before the trial judge. It was providing premium rates. This is one of the problems that Mr Bartlett said he encountered. Other matters which increased the risk of failure were the fact that Mr Bartlett obviously had to repay the sums he'd borrowed, and also there was an ongoing requirement to pay monies to the franchisor by way of the management service franchise. Now is perhaps a convenient time to take you to the franchise agreement, which you haven't actually been taken to. This is at the end of the supplemental bundle behind tab 17. So, lengthy agreement, but I'll turn to the salient parts of it. You may already have looked at the post-termination covenants themselves, which appear at bundles page 258 and 259. You can see that the clauses with which we are concerned at the moment are only two, effectively, of several clauses within the relevant sections. Bundle page 260, that's the post-termination restrictions on the franchisee. And then similar terms, 18.3, the post-termination restrictions on the individual. Obviously, we're concerned with the first two in each, which is the competition parts. There's also covenants in terms of seeking or to sell or obtaining orders, soliciting or enticing away other franchisees, enticing someone who was an employee and seeking to place orders with any supplier of franchisor. Now we can turn to Schedule 1, page 270. This sets out, first of all, the exclusive marketing territory. So that details within each postcode area and district the postcode sectors involved. You will see that Cardiff obviously has a slightly idiosyncratic way of numbering the sub-postcodes, but the evidence before the court was that this included all of the sub-postcodes within any one area, such that the exclusive marketing territory was, to use the word of Mr Justice Nugent, he then was, the interim injunction, contiguous. Management service free, before I go on to the rest of this, we just quickly turn to page 187 within this bundle, to tab 14. This is an annex, effectively, to my opening submissions for the trial on liability.
Yeah.
You may have seen this already, my lords, my lady, in which case I apologise. But this is the map.
Page
187, my lord.
Yeah.
So this was annexed to my opening submissions. It is a map produced on behalf of the claimant on the morning of the application for interim relief. If I explain what it does and then how it was produced. So the green section, that is an approximation, and it's only an approximation of what my learned friend at the time called the small peripheral ring, but I call the substantial buffer.
So that's the 5 miles there, is it?
Except it's apparently only in the region of 4 miles. And it was explained at the time that this was being put forward as what a 4 mile buffer would be. I'm not entirely sure why it was produced like that, but that's how it was produced. So that is an approximation of the buffer. You will see in the bottom right-hand corner, not very clearly, indication of scale, it says 4 miles. And that was the basis upon which this map was produced to the court. So the yellow section, the middle section, the hole in the donut, if you call it the half donut, if you call it that. That's the exclusive marketing territory. The green ring round it is an approximation, and it's an under approximation of the buffer if the second covenant is enforceable. Now that was produced because I, acting for the defendants via clips, had produced a rather Heath Robinson-esque map, which just really focused on the codes covered by the EMT themselves, which were in the middle. But that was the document put in on behalf of the claimant on the morning 17th of September 2020. Apologise for moving about the bundle back to Schedule 1 to the franchise agreement. So we looked at the description of the EMT. Other thing I'd invite the court to look at is the provisions pertaining to the management service fee. We can see the definition there. Management service fee means a weekly service fee in a sum based on a percentage of the franchisee's drained doctor business's weekly gross sales, excluding VAT, plus VAT there are set up below in Table A.
I've lost it. Which page are you on?
270.
I do apologise, my lady. It's page 270 where we were before.
Thank you very much. Yeah.
I should have asked everyone to
Yes,
have a
that's
finger
fine.
in it.
Management service fee.
Schedule 1, management service fee. So effectively, it operates by a mechanism of Table A, which is a decreasing percentage of management services based on an increasing invoice gross sales, subject to a collar in Table B, which increases over the duration of the management of the franchise agreement. So let's deal with Table B first. Again, it's dependent upon the territory population, but if we just look, for example, say territory population under £500,000, bottom of the page. So for weeks 27 to 104, so that's the 1.5 years of the first 2 years, if you like, effectively, following the commencement date, that's the minimum £1 payment. It then, I think, quintuples, or something like that, maybe not quite that much, to weeks 105 to 208 following the commencement date, and then doubles for the remaining period, so weeks 209 to the end of the term. So that's the minimum payment, for assuming a territory of under £500,000. If one goes over the page, one sees how the sums go up in a bigger territory. So that's the collar. The weekly invoice gross sales, I think in Table A, shows how the percentage decreases, as I said before, based on an increase of weekly invoice gross sales. And the final point is the MAP fee, just below the table on page 271 of the bundle. MAP fee means a weekly contribution to a national regional advertising and promotion fund of a sum equivalent to 2% of the franchisee's drained doctor business's weekly gross sales, exclusive of VAT, plus VAT thereon. And premises means the premises located 111 Harrison Drive, St Mellons, Cardiff, CF3 0PW, which was Mr Bartlett's home address and the registered address of Fredbar Limited. Now, moving on in my subheadings of this section of my submissions, and is apparent from these tables here, it was anticipated by means of the projections and everything else that the invoices and the work produced by the franchise could very greatly increase over time. I'm not going to revisit the debate which the court had with my learned friend this morning as to the status of certain paragraphs in the judgment are in terms of the representations. But the clear point is that that part of the judgment, as my Lord the Chancellor correctly said, was in the context of my submission and my cross-examination of the witnesses that the advertising was not accurate and indeed was negligently misleading. That claim failed, but nonetheless that is the context in which those paragraphs of the judgment are to be found. But nonetheless, the simple point is that it was envisaged that with the increasing of vans over time, the revenue and profitability and turnover of the business could substantially increase. Of course, these were projections, there could be no guarantees on them. Very briefly as to the circumstances in which the franchise agreement was signed. We've seen the agreement, tab 17 of the supplemental bundle. The judgment noted at paragraph 8, it was a lengthy, complex agreement. It was non-negotiable. It was only received the day before it was signed and was talked through with Mr Bartlett at his home. Given that it was only received that day before, there was no real opportunity to take advice in relation to its terms. And that would not be...
Am I misremembering? I thought he had seen it briefly before.
I was just about to come to that, my lord. What he'd seen before was a specimen, a pro forma, which he had asked for some evidence to give to the bank for the loan as to what was going to happen. So he was undoubtedly given some weeks before a pro forma,
Right.
but it was the standard form. So his details, his name, etc. weren't on it. He didn't look at it. But the agreement he was invited to sign was provided to him only the day before.
Where does the judge deal with this, Mr Grant?
Very good question, my lord.
I know he does, but I'm just trying
Yes,
to pick up.
if you bear with me, I'll change my glasses. Helpfully told by an engineer, paragraph 109. Yes, so it's 106 is the being sent on the 24th of September.
Yeah.
Copy of the standard form franchise agreement. You can see the terms of the judgment there. And paragraph 109 details the circumstances of the actual signing of the agreement. And there was no little evidence as to the actual circumstances pertaining to the signing on that day, but that need not
Well, I
trouble
think
the
the
court.
judge, just picking up on the point about sending it to the bank and not reading it, I think the judge deals with that in 106 and 107, doesn't he, by saying, well, he can quite understand why the defendant wouldn't have read it, but he had the opportunity to do so if he'd chosen to. That's what he's saying.
Yes, that's his finding, and I'm not
If you
challenging
produce
that.
a 100-page document, well, you can read it, I suppose.
Yes, exactly.
That's his point.
Yes. My lord, I've got through the first part of my submissions more quickly than I anticipated, partly because some of the ground has been covered this morning. I now turn to the legal position, and it may be helpful if I summarise what I think now is common ground between the parties.
Yes.
And this will undoubtedly come as good news to the court, to use the words earlier this afternoon. First of all, illegality even, I say is interesting, but to be ignored for present purposes. Patel and Mirza was dealing with a narrower case where the contract involves the commission of legal wrong. Chitty says that's different from these kind of situations. The claimant respectively agrees with that, and I respectfully agree as well. So, the question of illegality need not trouble the court. The next proposition, which should be common ground, is that a covenant in unreasonable restraint of trade is not invalid or void, but is only unenforceable. And the authority for that, I'm not going to take the court to it at the moment, is Office Overload, tab 8 of the authorities bundle, page 215 of the bundle. The next point, which should be common ground, but is important for one of the specific findings of the judge, is that the covenant doesn't apply when the contract is ended by repudiatory breach, which has been accepted. The authority for that is a case which the court hasn't looked at today, general bill posting. It's at tab 2 of the bundle, but perhaps rather than taking the court there, can I just show the court how it was dealt with in submissions to the trial judge?
That's where there's a repudiatory breach by the covenantor.
Yes.
Covenantee, rather.
Covenantee, yes.
The franchisor.
Franchisor, indeed.
That's general bill posting and Atkinson. Is that
Yes.
the case? Yes, that's what.
Yes. And
Yeah. Okay.
So that's undoubtedly correct as a proposition of law, but do we need to worry about that in the present case?
we do, because it suggested that the mutuality finding which the judge made rather ignores that. And my point is that the judge didn't ignore that. He well had this proposition of law in mind, and what he's talking about there is something really different. That is
what
for
he
the
says
purpose.
at 305K.
Indeed,
It's got nothing to do with this, it's about something completely.
indeed, yes. And I'll explain what it is in due course, but I can, for the time being, explain what it's not.
No, okay.
If we can turn the supplemental bundle to tab 14, page 177 of the bundle. This was my opening submissions, and over just shy of 6 pages from 177 to 182, I set out the defendant's position on the restrictive covenants, a number of which are recorded by the judge and feature in his judgment. But paragraph 85 is the one of particular relevance. That sets out the long-established position and the fact that a recent challenge to the correctness of that position was dismissed by Mr. Justice Chowdhury in 2018. So the takeaway point is that the trial judge well had in mind that the covenants fall away if, as in this case, there had been a repudiatory breach by the franchisor, which my clients had not affirmed. On that hypothesis, none of this would be relevant.
Yeah.
The next point is that, first of all, as my Lord Justice Arnold correctly said this morning, the first question is one of construction. And one construes these contracts in an entirely orthodox fashion, having due regard to the text and the context as one would do any other agreement. Next question is whether, this is really where the battle lines are between the parties, at least if I just sketch them out, whether the protection goes further than what is adequate to protect the interest. So I'll come back to that because that's really where the battleground is over. Another point of common ground is that the question of timing, the reasonableness or otherwise, is to be assessed at the date of entering into the contract, albeit that one can have regard and should have regard to what was in the contemplation of the parties. My learned friend refers to Harker Sinclair with the expectation of profit there. That's partly why I rely upon the very real risk of failure here, and why my submission, the judge was correct to have regard to those factors. Allied to the question of timing is the fact that we are concerned with the terms of the agreement and not with their performance. The performance by necessity post-dating the terms. And the final point, which my learned friend hasn't really dealt with at all, and I don't criticise him for that whatsoever, is the question of blue penciling or severance. Now, it is quite clear and recently confirmed by Egan-Zender that it is a formalistic approach. One can sever, but one cannot add in or replace. So the example given, I paraphrase, or may well have it in mind already, given in Egan-Zender from quite a well-established case was, if a covenant says one cannot work within 100 miles of the centre of Birmingham, and that is unreasonable, there is no way of saving that. By comparison,
You can't change 100 to 15.
indeed, your lordship's ahead of me, but that's the point. Well, if it said you cannot work in Birmingham or within 100 miles thereof, that is severable.
Yeah, because you knock out
Yes,
within
indeed.
100 miles thereof.
It's formalistic, it's arbitrary, but it's well established. And I'm not asking you to believe what I say, but what Lord Wilson said in Egan-Zender. So that is common ground.
Yeah.
The question is here really whether it is applicable here or not. So, my lords, my lady, that is the common ground as I foresee it between the parties. So now we get to the more interesting part. In terms of the enforceability of covenants, I challenge the finding by the trial judge at 296 of his judgment that the approach to be taken is more akin to the treatment of clauses in contracts for sale than for clauses in employment contracts. I'm going to take this in stages and we'll see how far we get this afternoon. The first point is the question of public policy, and hopefully what I'm about to say squares the exchange between my lady,
Good, thank you.
Justice Whipple, and what my learned friend said this morning. This is ultimately a question of public policy, and what one is reconciling are two competing principles: sanctity of contract, or freedom of contract on the one hand, and freedom to trade on the other. That's been established since at least Herbert Morris. The other wording which is sometimes used, I think Lord Shaw in Mason and Provident, which you don't have in the bundle but is quoted elsewhere in Scully and Lee, it's the antagonism between the right to bargain and the right to work. That's also reflected in the extracts of Chitty, which the court has. I say this is ultimately a question of public policy, but there are principles which one uses to determine whether a particular clause is reasonable and enforceable or not. What neither party is seeking to do is to say, well, if the court is against us, we seek to salvage, in my learned friend's case, or strike down or render unenforceable, in my case, the agreement on an additional point of public policy. So in other words, if, arguing against myself in the moment, that this court were to conclude that the trial judge erred and that the covenants provided do not go further than is reasonably required, I then don't seek to render unenforceable the clause by reference to some additional concept of public policy. And the converse is true of my learned friend.
But your point is that the whole concept is one of public policy.
Indeed, yes. Yes. And my next submission, I'm about to turn to the quality of bargaining power. I don't know, my lord, how long you
Well,
willing
I
to sit.
think we'll go on till 4:15.
Well, in which case I will make a start then. My learned friend made a submission this morning, which in my submission...
Sorry, can we just get back to public policy?
Yes,
you can
certainly.
tell that I got a bit stuck on that one. As I understood the submissions that you're facing, they were to the effect that I could leave public policy on one side and disregard it, and the questions were tightly focused on the franchisor's own interests. So in other words, what was their goodwill and how could they reasonably protect that goodwill? Do I understand you to be saying, I'm sure you'll come on to it,
Yes.
but do I understand you to be saying, Mr Grant, that public policy infects all aspects of this? So in fact, we're coming on now, I think, to talk about equality of bargaining power,
Yes.
which is very much a public policy
Exactly.
element. And so
Yes.
that's where it all comes in.
Yes,
Is
exactly.
that right?
Yes, so the first thing I'm going to deal with is equality of bargaining power, which I say is a manifestation
Yeah.
of public
It's
policy.
an obvious incident of
Yes.
public policy.
Exactly. So my own friend said this morning that inequality of arms was utterly irrelevant to the test of the reasonableness and the enforceability of these covenants. In my submission, it's not, and there is the highest authority against my learned friend. I'm going to take you through some of the early cases we have in the bundle, most of which are House of Lords decisions, to show that the court's scrutiny of covenants turns to a considerable degree on the equality of bargaining power and the encouragement of commercial activity, and whether the agreement in question is negotiated or not. And that's
The House of
applicable.
Lords was all over this point, if I put it that way, in Esso and Harper's Garage.
Indeed, and that's why people refer to that case, even though it's to do with mortgages of garages. But the point is apparent in the entertainment cases, to use the terminology of this morning, and elsewhere.
Well, when the principles are summarised by Lady Justice Carr and Quantum Advisory, there's no suggestion that somehow that these are other than principles which apply across the board to all instances of covenants in restraint of trade. And she simply cites franchising agreements as an example
Yes.
of the type of contract where the principles have been considered, and it doesn't identify it as being in its own little box, which really is what Mr Jones was driven to.
Indeed, and I say that is, with great respect to him, simply wrong. But this is a cornerstone of the enforceability of these agreements. It has been so since at least Nordenfelt. If I can turn to that now, we just need the authorities bundle. Now, you've already seen page 34 using the bundle page numbers. The extract at page 565 of the report. The public have an interest in every person's carrying on his trade freely. What you weren't shown was across the facing page 35
Hang on a
of,
moment, Mr Grant, I'm sorry.
I do apologise, my
Just
lord, I
doing
should
some
have paused.
weightlifting over here. Master Rolls would say if we'd had electronic bundles, then none of this would matter. Okay,
Yes, you would say that.
page.
Your lordship certainly wasn't inviting a comment on that, so I'll
No,
continue.
it wasn't.
Page 35, so Lord Martin.
Yeah.
It's halfway down the page, it's the highlighted passage. To a certain extent, different considerations must apply in cases of apprenticeship and cases of that sort on the one hand, and cases of the sale of a business or dissolution of a partnership on the other. A man is bound an apprentice because he wishes to learn a trade and to practice it. A man may sell because he's getting too old for the strain and worry of business, or because he wishes for some other reason to retire from business altogether. Then there is obviously more freedom of contract between buyer and seller than between master and servant, or between an employer and a person seeking employment. Next case, which is one we haven't looked at, I'm not going to repeat material which has been already before the court. But tab 5, Court of Appeal decision, M&S Drapers, a firm, and Reynolds. Now, the individual, in this case, was a collector salesman on a weekly wage of £10 in the 1950s, which according to the RPI index approximates to £340 current money. And the Court of Appeal made some comments about the importance of his position. Bottom of page 125 in the bundle. Below the second punch hole. When I find the clause so wide as to cover his customers and is for so long as 5 years, I think it is an unreasonable restraint of trade. We referred to the case of Guildford Motor, which is in the bundle, but I think that case is quite distinguishable for the reasons given by Lord Justice Hodson. A managing director can look after himself. A traveller is not so well placed to do so. The law must protect him. That, I say, speaks for itself. In terms of Esso Petroleum, the court already has the point. The express wording, bundle page 158, is where two experienced traders. Jumping ahead, the most recent case before the court, that explains Harker Sinclair, where perhaps unusually, maybe even uniquely, the covenantor was probably the party in the stronger bargaining position.
Sorry, which?
That was Harker Sinclair. I'm just jumping ahead for the moment.
Yes, yes.
Perhaps uniquely, the covenantor was the stronger bargaining party. Undoubtedly a relevant factor for the reasons we've seen in the judgments of the court. We've seen Schroeder and Macaulay. My learned friend tries to sideline it, but nonetheless,
Well,
there's reference
I think
in
it
there.
might be helpful to look at a little more detail of
Yeah.
that, because he didn't really take us to the relevant passages.
Yes. Well, I shall do so then, my lords. It's tab 7 of the bundle. And first of all, it's page 209, the beginning of Lord Diplock's speech.
It's really Lord Diplock more than anybody else.
It is. And the main bit is the sidebar part on page 210, and I can just take the court to one specific bit on page 209. Just above the first punch on fact by letter D, in order to determine whether this case is one in which that power ought to be exercised, what your lordship...
Sorry, where are we?
Just letter D, my lord, page 209.
Oh, yes, got you. Got it.
In order to determine whether this case is one in which that power ought to be exercised, what your lordships have in fact been doing has been to assess the relative bargaining power of the publisher and the songwriter at the time the contract was made, and to decide whether the publisher had used his superior bargaining power to extract from the songwriter promises that were unfairly onerous to him. Now, that's slightly different, admittedly, but it's the first articulation of this concern of bargaining power. If we turn over the page, Lord Diplock deals with standard forms of contracts at the top of the page. It's the paragraph beginning just by letter E. Perhaps I can ask the court to read the sidebarred passage for yourselves.
I mean, intriguingly, actually, if you go back to page 209, page 1315 of the report, between E and H, Lord Diplock there refers to the approach of the 19th century judges to striking down bargains which are unconscionable, where there was one party had stronger bargaining power than the other. And he says, although lip service was paid to current economic theories, one looks at what they said in the light of what they did, one finds they struck down a bargain if they thought it was unconscionable as between the parties to it, and upheld it if they thought it was not. But tantalisingly, he doesn't identify which particular judges in which particular cases he had in mind. And if you look at the cases cited, only one 19th century case was cited, Young and Timmins, and I don't know if that's relevant.
And
But,
yes, it will be undoubtedly be a mix of cases pertaining to that time.
yeah.
Certainly that's at the time when the concept of undue influence and the like was really being developed, for the Chancery Court in particular. But a lot of those cases will not be ones concerning the relative bargaining power of parties. My lords, if you're happy just to return, it may well be that my lords and my lady have read the passage in 210. Again, that focuses on the bargaining power.
So Diplock equates the idea of a take it or leave it attitude
Yes.
as raising a presumption of superiority of bargaining power, which must make sense. If you can say to somebody,
Indeed,
take it or
yes.
leave it, that must mean that you're
Yes.
in a superior position.
Yes. My lord, I'm conscious of the clock, but I can hopefully conclude this element of my submissions on equality of bargaining power within the next 8 minutes. Next case I want to go to is Bridge and Deacon. We've looked at it already, but it's important for one additional point, which again is a question of mutuality. So this is a partnership of a well-established and sizable firm of solicitors in Hong Kong. The argument effectively between the parties was whether the partnership case there fell much towards the master-servant line or the vendor-purchaser line. We know what the court's conclusions was. But what's important, the reasons I'll develop tomorrow, is page 227 of the report, sorry, 227 of the bundle even. Lord Fraser. Below letter E deals with Nordenfelt, and then at F, Esso Petroleum. And then an important sentence beginning just after the quotation marks, just above letter G. The justification for the limitation in that type of case is that it enhances the price which the vendor can obtain for his business. See Mitchell and Reynolds. Even in contracts of this type, it is necessary to consider whether restrictions on the vendor of the goodwill are fairly and properly ancillary to the sale. Then turns a few lines down to the employment cases. Notes that in cases of this type, only much more limited restrictions are normally enforceable, and if their effect will merely be to protect the employer from competition from his former employee, they will be invalid unless the circumstances are unusual. And then if you're happy, we'll turn over the page. There's a quotation from Herbert Morris, which we've seen more than once. Then we get to just above letter E. The agreement in the present case, being one between partners, does not conform exactly to either of the types to which reference has just been made, although it had some resemblance to both. Their lordships are of opinion that a decision on whether restriction in this agreement are enforceable or not cannot be reached by attempting to place the agreement in any particular category, or by seeking for the category to which it is mostly analogous. The proper approach is that adopted by Lord Reed in Esso Petroleum, where he said, I think it better to ascertain what were the legitimate interests of the appellants which were entitled to protect, and then to see whether those restraints were more than adequate for those purposes. Significantly for our purposes, what were the respondents' legitimate interests will depend largely on the nature of their business and on the position of the appellant in the firm. So again, that's identifying a number of factors which flow through these, including, but not limited to, the equality or inequality of bargaining power. Equality of bargaining power is also referred to in the Cavendish Square Holdings case, which the court will be familiar. It's not in the bundle. Let's mention it briefly. And then finally, conclude this part of my submissions with the Harker-Sinclair case, which I've already touched upon. You've seen the passages in the judgment. I don't need to take it back again, but paragraphs 83, we see reference to Lord Diplock's speech in Schroeder, amongst others, and the focus there on the equality of bargaining power. So to conclude this part, I say it is absolutely clear and established by authority at the highest level that equality of bargaining power is a significant factor in cases of this type. Even where there is dissent, it is qualified and really goes to the same ends. And that's the case of Dorney Day, tab 15.
Sorry, I'm just looking at 83 and into Harker-Sinclair. I'm not sure we were actually taken to it before. And having looked at it while you were speaking, it seems to me it is of some importance. So
Certainly.
let's just take a minute to look at
Let's
it.
just have a look at that and then we'll come back to the other cases
Yes.
in the morning.
It's really the last sentence, isn't it?
Indeed, yes.
General relevance considering the reasonableness between the parties that there was no inequality of bargaining power in this case.
Yeah.
So conversely, if there is inequality of bargaining power, that is relevant.
Indeed. And that was the point I was clumsily trying to make 10 minutes ago by saying this is perhaps uniquely the case where the covenantor was, if anything, in a stronger
Yes,
position.
well, I recall you mentioned that, but
No,
it's helpful just to see how it
yes,
was put.
certainly. Unless my lord has any further point on that judgment, I'll turn back, if I may, to Dorney Day at paragraph 15. This provides some slight doubt to the importance of bargaining power, but effectively comes up with something of comparable value.
Yeah, that's
tab 15. What you have in here is the first instance judgment of Justice Robert Walker, as then was, and then the Court of Appeal decision. I'm simply going to take you to one point. It's in Miss Justice Robert Walker's decision, bundle page 310. Top of page 310, the paragraph beginning 3 lines down, those are features which makes this case unusual. The maps ask the court to read to the end of that paragraph.
sorry, I'm not getting by letter.
So it's the top of page 310, 3 lines down.
These are the features that make this
Yes,
case unusual.
exactly.
Yeah.
My lord, is that a convenient time? So I'm now moving on to a slightly different topic.
Convenient moment.
Yes.
We'll break them for the day.
Then I'll review my estimate overnight and update the court at the beginning of tomorrow.
Well, 10:30 tomorrow morning then, please.